Many people, and the problem I sometimes have is trying to explain to individuals what are the differences between guardianship and custody. They seem to use the word they seem to use the word custody all the time. So for every scenario regarding care, contact, visitation, consent issues, for example, the child applying for a passport, or the child applying, or the parent applying to a school for the enrollment or admission of a minor child, the child leaving the country, and various examples, they will use the word custody. However, there's a difference between the term custody and guardianship. And that's what I'll try to touch on today. And later on, I'll deal with the issue concerning this refusal of access to minor children. It's an important issue. And for that, I shall have a look at the Children's Act, Section 35, dealing with the refusal of access or refusal to exercise parental responsibilities and rights in relation to minor children. So to follow up from last week, guardianship issues. Guardianship deals with the legal aspects of a minor child. Legal, for example, a minor child wants to purchase property or sell property. A minor child, obviously the ages of 17 and below. The moment you turn 18 years old, you're no longer a minor, you're an adult. A minor child wants to obtain a passport. Both parents' consent is required. Legal stuff. A minor child needs to enroll into a school. The school asks, we require the consent of both guardians, and so on. So I think you follow where I'm going to. It has nothing to do with physical care of a minor child, like contact rights. However, it deals with the legal problems. And my desk or my office, we get inundated with such queries whereby there is not much problems regarding care and contact. For argument's sake, the other parent does not really care about the minor child that much, or he or she exercises contact based upon an agreement they have. That's it. However, there are other challenges and problems which they face, and that is when it comes to consent issues, guardianship issues, where the law expects both parents, or the law prescribes that both parents consent to certain type of decisions. And for example, a decision would be a minor child wanting to apply for a passport or leaving the country. Both guardians have to consent to it. Then, of course, on the other hand, we have care, custody, custody being the old term, dealing with a situation whereby you have physical control over the minor child. If you have custody over a minor child, then basically the minor child will live primarily with you. Monday morning until the Friday, where the other parent might decide, or might not decide, will exercise contact to the minor child. I got a technical issue here. Let me just sort this out quickly. There it is. Could have caused a bit of a streaming problem. My apologies for that. So, moving forward, custody deals with the physical care. A parent may have full guardianship rights or co-guardianship rights in relation to a minor child, but that specific parent might have no contact or care rights to the minor child. And that's possible, and it happens in practice, whereby the parent might, for argument's sake, be very angry, abusive towards a minor child, have certain issues. However, for all other purposes, the parent might be logical and sound. Therefore, he or she may have no contact rights, or maybe limited contact rights, maybe via a telephone and so on. However, when it comes to legal aspects regarding the minor child's life, that specific parent will have to be consulted on. So that is where we look at the difference between guardianship rights and contact rights. You can distinguish between the two. Therefore, if you are a mother, and I'm using that example because that's a general scenario, the opposite can also apply. If you are a mother and the father of the child went missing, he is no longer involved in the child's life, he has no interest in being involved in the minor child's life, etc. and you are having problems regarding consent issues. Wherever you go, they keep asking you, where's the father? The father has to give consent. Under those circumstances, should you approach an attorney, a legal practitioner, as the case may be, your argument or your request would not be, I would like to have sole custody. You are already practicing sole custody. The other parent is not involved in the child's life, so there's not much to worry about there, unless you are concerned that he or she might come out of nowhere and present a court order, a divorce order, granting him or her care and contact rights, in our scenario, or him. But if the other party has none such rights, but you have a problem every time you approach an authority, they ask for the co-guardian's consent. Under those circumstances, your request to your legal practitioner would be, I would like to obtain sole guardianship rights over my minor child, not custody rights. I need to inform the public all the time that there's a difference between the two terms, and I do not for one second think I'm being pedantic, because someone watching this specific video might not have seen our previous videos, or they may not understand, from a layperson's point of view, what are the differences, unless you unpack it and you make sense of it. Therefore, and in concluding on this specific point, you need to know that there is custody rights, care rights, visitation rights, physical aspect rights, whereby you will have physical contact with a minor child, you will care for the child, etc. And then there are the guardianship rights, which are legal rights, consent issues, etc. Care rights includes maintenance, shelter for the minor child, of course having contact, forming a bond with the child. Nothing to do with guardianship. Guardianship is a legal right which you have to exercise when it comes to certain issues of the minor child's life. As I mentioned earlier on, passport applications, relocation, admission to schools, the minor child, selling immovable property, etc. And if the minor child wants to get married under the age of 18 years old, then both guardians have to consent. Now we're moving forward to the scenario of what happens if parties do not adhere to a court order. What happens then? What can you do? Is it a criminal offense? What does the law say, etc.? Now, I have certain challenges or certain problems with the law when it comes to the exercising of parental rights and responsibilities. The section we're looking at now basically deals with criminalizing the act of refusing another party his or her rights in terms of a court order when it comes to the exercising of his rights. For example, a parent who is entitled to have contact, access, see the child on a certain day, and the other parent says, no, you cannot have contact, despite there being a court order. So the law comes in and says, you're not allowed to do that. You're not allowed to refuse another person contact, care, access to a minor child if a court order affords that person that specific rights. So we accept that. The challenge I have for the law is, why is a party only protected or his or her rights enforced when it comes to him exercising his rights, but not when he or she has responsibilities when it comes to those rights? Meaning, if a parent is entitled to have contact on a Saturday afternoon, the mother, she played around with the schedule, she took the child maybe to extramural activities, maybe to some running or to some swimming, whatever the case may be, or went out for a chocolate, whatever the case is. She made sure she comes home at 2 o'clock because the father, in terms of a court order, is allowed to exercise contact at 2 o'clock. She made sure the child is fed, dressed, etc. Now the father doesn't appear. He doesn't pitch. What can the mother do? She is not refusing contact because she is allowing him to have contact in terms of the court order, in which she must do. There's no privilege here. However, the father decides not to pitch. He sends a WhatsApp message an half an hour before the time, or 1 minute past 2, sorry, I can't make it, I have other plans. What happens then? Can he be held criminally liable for that? The law obviously doesn't deal with that. But, however, if the scenario was different and the mother in this case, in our scenario, did not have the minor child ready for collection at 2 o'clock. The father pitched up, the child wasn't there. The mother is still out somewhere with some friends. She WhatsApp the father, I'll be an hour late, I'm coming back later, I'll drop the child at your house, etc. She does that for argument's sake. The father is disappointed because now another party is basically refusing in contact to the minor child. That is a refusal. Even if you're saying I'll drop the child an hour later, he's entitled to that specific hour, you refuse in contact. And then the law kicks in and the law can punish or penalize the mother for that. But if the father does not want to exercise contact, the law doesn't really assist you. So that's a problem I have with our law. I expect the law, when the law is applied, to apply both sides. You want to have contact to your child, you must have contact, you should have contact. It is your right, it's a child's right to have contact as well. It is a child's best interest, it's important for family, for development of both sides, the child's development, the mother's development, the father's development, etc. However, the blade should be sharp on both sides. If a parent decides not to exercise contact, a right which he or she has, in terms of a court order, without any good reason, he or she must be punished for that, because the child loses out. The child is waiting for dad to come collect him or her. Your daddy in a pitch. But should mom decide to limit the dad's contact, the father can go to the police and lay criminal charge. So that's a problem I have with our law. I expect the law to be equal and to look after the best interest of the child by enforcing both parental rights and responsibilities. Section 35 of the Children's Act, an important piece of legislation, it basically criminalizes, my apologies for that, a party whose conduct entails limiting a parent contact to a minor child if there is a court order. Let us unpack it. It says the following: refusal of access or refusal to exercise parental responsibilities and rights. That's a heading. But confusing, but let's move on. Any person having care or custody of a child. So in our scenario, we say it's a mom. Contrary to an order of any court or to a parental responsibilities and rights agreement that has taken effect as contemplated in section 22.4, that's another agreement, almost like a court order, refuses another person who has access to that child or who holds parental responsibilities and the rights in respect of that child in terms of that order or agreement to exercise such access or such responsibilities and rights, or who prevents that person from exercising such access or such responsibilities and rights, is guilty of an offence and liable on conviction to a fine or to imprisonment for a period of not exceeding 1 year. A mouthful. It's strange how they drafted this piece of legislation. They use the word access or custody and care in this paragraph, and in other sections of this legislation they don't use the word access. But be that as it may, we know exactly what they mean. So the long and the short of it is, if you are entitled in terms of a court order or for an agreement that has been legalized, etc., to exercise contact to your minor child, and another parent limits that right, prevents it from happening, that parent who is preventing you from having contact to your minor child or access is guilty of an offense and liable on conviction to a fine or to imprisonment for a period of not exceeding 1 year. What do you do then? So here, applying our scenario again, dad phones the mother, WhatsApps the mother, 10 to 2, I cannot make it. Now mom has to look after the child. She done what she had to do, but now she has to look after the child because dad now decided, I'm now deciding on this specific weekend, I'm having another weekend away from my child. Last weekend I did not have contact because I had contact the previous week, but this specific week I'm not having contact. I'm not being prejudiced to any parent here. I'm using an example. I can swap the example around as well and say the father is the one who has primary care. But let's be easy here and make it more sensible for everyone to understand. But if the mom, now she said, last week dad, he cancelled on me. He did not come collect the minor child at a certain time, and I had to look after the child. This weekend, I'm deciding now I'm going to go and enjoy myself. And because there's a possibility of him not coming in any event from cancelling again, and the mother does not bring the child home at 2 o'clock, and the father pitches up, no one there. She phones the mother. Mother said, "Oh, sorry, we went out for a long drive. We can only be back in 4 hours' time, etc." She committed an offense. She committed a criminal offense. But the long and short of the matter is, I might be a bit trivial over there, but it happens quite frequently where parents are refusing other parents from having contact for no legitimate reason, for no good reason. The takeaway is that you can be held criminally liable for not complying with a court order regarding care and contact. Let us move on. Subsection 2A says the following. A person having care or custody of a child whereby another person has access to that child or holds parental responsibility and rights in respect of that child in terms of an order of court or parental responsibility and right agreement as contemplated in subsection 1, the previous paragraph we referred to earlier on, must, upon any change in his or her residential address, forthwith in writing notify such other person of such change. So, what is the law saying? The law is saying, if you move, you're the primary caregiver, you're the one that cares for the child, and the other party is entitled to have contact, access. Should you move, you need to inform the other party of that move, your new address. Then it goes further, subsection B. A person who fails to comply with paragraph A is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. Therefore, if you do not inform the other party that you have moved, you are guilty of an offence. I understand the logic behind that, because you might want to come and have contact with a minor child, and now they find out that the child moved. Obviously, you limiting contact, and the other parent would like to know where the child resides. So it's important that we comply with orders, and we make orders usable and friendly. And an order of court is not there to complicate issues. An order of court is there to fix problems and to regulate issues going forward. And therefore, parties will have to work together regarding court orders. That is it on my side. If you have any questions, you're welcome to pose it. I think we can summarize that we have dealt today with the issue concerning the difference between guardianship and custody, and at the same time, what happens if a party limits your right to contact or access in relation to a minor child if there is a court order in place or parental rights and responsibilities agreement in place. I hope you have a wonderful day and hope to see you online soon. Thank you very much.